Matters before the court on the defendant's motion to enforce and modify child support.
I never received any support, nor I can even dig my stuff. So life is just like a nightmare with two young kids.
So are you saying that there is no support order at the current time?
The children live with me full time. Miss Parr only sees the children for an hour a week. She pays me child support.
As Mr. Spring states, there's an order for requiring you to pay child support. So it wouldn't be appropriate for you to enforce the order because all you have to do is pay the support. I've read all the pleadings in this matter. Ms. Parr, I don't quite understand. You said that this order was entered back in 2017. And I don't understand why it would take 4 to 5 years for you to correct any inaccuracies that you state occurred, basically 5 years ago. And again, the allegations that you make as it relates to the referee do appear to be fantastic. So I'm at a loss as to what you're alleging.
Your Honor, I was very weak after threatening like some kind of narcissistic abuse that for so long, and I was afraid to bring things up. And every time I have a attorney, they told me not to, and now I was alone. And I think that's the only way that the court can see things clearly.
Okay, so what's the basis for your motion?
As the law says, when there's an existing case, everything has to be filed on the existing case. Instead of this case, they just come up with a new case without the court involvement and take over the old case. And when I was suffering financially to taking care of my kid.
Okay. Well, this case was consolidated back on February 5th, 2018. And that's not unusual that if you got, a support case and a different, like in this case, the DC case, the cases were consolidated. That shouldn't impact the case at all because you can still make any corrections that need to be made. So again, I'm still not understanding what you're asking for.
I am asking for your honor because of all 2 years unpaid child support. That's what I wasn't able to come up with money to hire an attorney to presenting me until everything went downhill.
Okay, that still doesn't tell me what's the basis for your motion. You're saying you didn't have money to be able to fight it at that time. That's understandable, but it doesn't tell me why we're here today and what the basis is for enforcement or modification.
Well, they consolidated without the court involvement of February 5, 2018, but does not include the support order. I take the attachment. They cross out with a pen. And because of that, I never received any support, nor I can even dig my stuff. So life is just like a nightmare with 2 young kids, and to still affect the case today.
So are you saying that there is no support order at the current time?
No, Your Honor. That order has been finalized on December 2017, but I does not receive a penny since the day you entered the final order, Your Honor.
Well, maybe I can get Mr. Spring. Maybe you can enlighten me. What's happening if you know?
He probably know because I am not aware of.
Okay, I've turned it over to him. I want to hear from him. So, Mr. Spring, enlighten me what's happening.
We've gone through several evidentiary hearings with the front of the court, and this is a support order that was put in place by front of the court, not by any agreements or anything like that. So this is just the state putting this order in place. The children live with me full time. Miss Parr only sees the children for an hour a week supervised. So she pays me child support, and that's it. There's nothing other than that.
Ms. Parr, is that your understanding that the support order and basically obligates you to pay support. You are the support payer.
In the DC case, yes, Your Honor, but in the DS case, you awarded me full custody of both the minor children until the DC case come out in 2018, and then Mr. Spring just start setting a trap with me, all witnessed by the minor children. I attach all the police report as well. He against me in PPR with false police report. And then that's how the DC case come out with the court without the court involvement. And also in May 2023, 2018, they told me we have meditation at your courthouse. And I was there witness with Marco from the safe place. They told me if I did not sign a halfway cut down the child support amount on the DS case, on the DC case, I will never receive a penny. And that time I already took 10,000 personal loan just to buy everything needs for my kids. And
Okay, ma'am, try to focus on the motion. You file a motion for enforcement and modification of child support. I don't need to get into all that extraneous stuff. I just want to know what's the basis for your motion.
Everyone should obey the court order, Your Honor, and this is the order still alive because they did not consolidate with the DHC case. They only consolidated the custody case. You can see that they cross out with a pen.
Well, in this particular matter, the only thing I could suggest, Ms. Parr, is that you proceed through this matter with the front of the court and see if you can't straighten out, again, the consolidation and the other, because quite frankly, as I look at this matter, as Mr. Spring states, there's an order for requiring you to pay child support. So it wouldn't be appropriate for you to enforce the order because all you have to do is pay the support. There'd be no issue in that regard. And apparently the front of the court has not pursued any action in this matter as well to enforce the order. So I'm really, as I stated, I'm at a loss as to what the situation is in this particular matter. So all I can say is you might want to proceed with the front of the court, as they have obviously involvement in both cases, the DS and the DC case in this particular matter. So the court just doesn't find a basis for the motion at this particular time. So I'm going to deny that motion. Mr. Spring, I'll ask in this matter that you would prepare an order denying the motion. And you can submit, if you submit that within 7 days, you can do it without having a hearing. And if you don't, then you're going to have a hearing to get the order entered. Okay.
Okay.
Thank you. The court will end this matter at 10:49 a.m. You're free to go. Have a good day.
The plaintiff, he is alcoholic and there's ongoing sustained alcohol abuse to the minor children, and he don't take them to counselor once or ever. So this can affect their mental seriously. It can be like a long time.
Court will note the appearance of Ms. McIntyre on behalf of the defendant. We have two matters before the court. The first is Ms. McIntyre's motion to withdraw as counsel for defendant, and thereafter defendant's motion to modify custody, parenting time, and support. We'll take Ms. McIntyre will take your motion first. It's my understanding, based upon the pleadings, that the defendant is not opposed to your withdrawal. Is that correct?
That is correct, Your Honor. And this court previously actually ordered that I was to withdraw. And I think that there was a delay, or the paperwork got lost when I submitted the order under 7-day. And so that's why I had to renotice it out. But the court has already granted that request.
Okay. Ms. Parr, are you opposed to the motion to withdraw?
Yes, she just don't do anything, so there's no point her in the case. I just need she refund at least a couple thousand.
Okay, well, that's not before the court. Her motion is to withdraw is before the court. All that other stuff is stuff you'll have to take care of separately. It doesn't involve the motion to withdraw. So the court will grant the motion to withdraw. And Ms. McIntyre, do we have an order in the file now?
Yes,
Okay.
you do.
We will get that entered, and then you are able to withdraw at this point. And if you wish to leave, we'll proceed with the defendant's motion.
Okay, thank you, Your Honor.
Okay, thank you. Have a good day.
Thank you, you too.
Ms. Parr, we'll proceed now with your motion for modification of custody, parenting time, and support. Go ahead.
Well, the kids are basically is in a very, very bad situation right now. So they really need to come home. The court need to look into the deeper how everything went just some kind of upside down. And they need to be a loving home. They need to be cared. They deserve everything. So there's a lot of allegation like sexual abuse, physical abuse. They all are attached with the motion.
Okay.
And
Anything?
also the plaintiff, he is alcoholic, and there's ongoing sustained alcohol abuse to the minor children, and he don't take them to counselor once or ever. So this can affect their mental seriously. It can be like a long time.
Anything else that you want me to consider?
Can they come home, my kid?
Well, I'll ask Mr. Spring, do you have any response to the motion?
I would like this to be rejected. The situation with their mother has not changed, so I don't think that there should be any change in the custody order. Ms. Parr only sees the children for an hour a week, supervised, and I think it should stay that way.
Okay, thank you. Anything else, Ms. Parr?
Yes, Your Honor. I really wish you grant my motion, because nothing is a lie on that motion. Everything is based on the truth. That the court does misunderstand this all year long.
Well, the court notes that Ms. Parr has filed multiple motions in the past, and her motion now simply reiterates the same allegations that she's previously repeatedly asserted. The motion basically throws everything, no matter how old, against the wall, hoping that some of it will stick. And in this matter, if and when the defendant has new allegations that satisfy the holding of Barker versus Grassmeyer, which means proper cause or change in circumstance, which is the threshold for having an evidentiary hearing, the court will then consider the motion at that time. Ms. Parr, what I've stated is, as you look through your motion, you just keep throwing the same thing that you've alleged over the last couple years in the motion, not setting forth anything new to establish the legal basis for the court to consider. And again, that's the Barker versus Grassmeyer case. And as a result, the court, at the time that you provide new allegations that satisfy that threshold, the court will consider it. But at this point, the court will deny the motion at this time. Mr. Spring, you're going to have to do an order, submit under 7-day notice of entry, denying the motion. Okay, sir?
Okay, sir.
Okay. Thank you. We'll conclude the matter at 10:37 a.m. You're free to go. Have a good day.
In today's courtroom showdown, a mother walks in claiming she never received a single penny of child support, despite a court order that supposedly dates back years. But within minutes, the judge begins questioning her story, and what unfolds is a confusing web of accusations, custody battles, and legal misunderstandings. Was the system failing her, or was she completely misreading the law? Let's break down exactly what happened inside this tense courtroom. Now the courtroom dynamic shifts when the opposing party, the father, finally speaks. According to him, the children actually live with him full-time, and the mother only has 1 hour of supervised visitation each week. That's a huge detail because it flips the entire narrative. If the father is the primary custodial parent, then legally speaking, it would make sense for the mother to be the one paying child support, not receiving it. Child support is based largely on custody arrangements and financial responsibility for the children's daily needs. So suddenly the judge isn't looking at a parent who was denied support, he's looking at a parent who may actually owe support under the existing order. Later in the hearing, the situation becomes even more complicated when the defendant begins making serious allegations about the father, including claims of alcohol abuse and potential harm to the children. These are extremely significant accusations in family court. However, even allegations this serious must meet strict legal requirements before the court can reopen custody decisions. Judges cannot change custody arrangements based solely on repeated claims that have already been reviewed. The law requires something called proper cause or a change in circumstances. Without new evidence or new developments, courts typically refuse to revisit old arguments, and that appears to be exactly what's happening here. The judge ultimately explains a critical legal concept referenced in the hearing, the Bodvarka versus Grameyer standard, a well-known case that sets the threshold for modifying custody in Michigan family courts. Under that standard, a parent must show new circumstances that materially affect the child's well-being before the court will even schedule a full evidentiary hearing. In this case, the judge determines that the motion simply repeats allegations that have already been raised multiple times in the past. From the court's perspective, the motion appears to be throwing every possible accusation into the filing, hoping that something might stick. Legally, though, that strategy rarely works. By the end of this hearing, the judge reaches a clear conclusion: there's no legal basis to enforce or modify the existing child support or custody orders at this time. The motion is denied, and the court instructs the opposing party to prepare the formal order closing the matter. What makes this case so striking is how it highlights the difference between emotional arguments and legal arguments. Family court can be incredibly painful and complex, but judges must rely on evidence, procedure, and established legal standards when making decisions that affect children's lives. Now we want to hear from you. Do you think the judge handled this situation correctly? Or should the court have looked deeper into the allegations presented? If you found this courtroom breakdown insightful, hit the like button, drop your thoughts in the comments, and subscribe for more intense real courtroom analysis just like this.